Section 299, Requisitioning Extraordinary General Meetings of a Private Company. 1. The directors of a private company, despite a provision in the constitution of that private company, shall duly convene an extraordinary general meeting of the company on the requisition of a. Two or more members of the company or a single member holding not less than 1/10 of the shares of the company. Or b. In the case of a company limited by guarantee, 1/10 of the total voting rights of the members of the company. 2. The requisition shall state the nature of the business to be transacted at the meeting and shall be signed by the requisitionist and sent to or delivered at the registered office of the company. 3. If the directors do not, within 7 days from the date of receipt of the requisition at the registered office of the company, proceed duly to convene a meeting for a date not later than 28 days after the receipt of the requisition, the requisitionist or any of them may themselves convene a meeting, but a meeting so convened shall be held within 4 months from that date. 4. The reasonable expenses incurred by the requisitionist by reason of the failure of the directors to duly convene a meeting shall be repaid to the requisitionist by the company, and the sum of money so repaid shall be retained by the company out of the fees or other remuneration of the directors who were in default. 5. For the purposes of this section, the directors have not proceeded duly to convene a meeting if they do not, within 7 days after the receipt of the requisition at the registered office, cause notices of the meeting, to transact the business specified in the requisition, to be given in accordance with paragraphs 1 to 3 of the 8th schedule. Section 300, Appointment and Removal of Directors of Private Companies. 1. The appointment and removal of directors of a private company may, subject to sections 171 to 176, be regulated by the registered constitution of the company. 2. In the absence of a contrary provision in a registered constitution of the company, each of the existing directors shall continue to hold office until the director vacates office under section 175, or is removed under section 176. 3. A company may at any time by ordinary resolution fill a vacancy in the number of directors and may at any time by ordinary resolution increase the number of directors, but the total number of directors shall not exceed the maximum prescribed by the registered constitution of that company if it has one. Section 301, Unanimous Agreement by Shareholders. 1. Where all shareholders of a private company agree to or concur in any action which has been taken or is to be taken by the company. A. The taking of that action is deemed to be validly authorized by the company despite any provision in the registered constitution of the company. And B. The provisions in any of the constitutions referred to in the second, third and fourth schedules shall not apply in relation to that action. 2. Without limiting the matters which may be agreed to or concurred in under subsection 1, that subsection shall apply where all the shareholders of a private company agree to or concur in a. The issue of shares by the company. B. The making of a distribution by the company. C. The repurchase or redemption of shares in the company. D. The giving of financial assistance by a company for the purpose of, or in connection with, the purchase of shares in the company. E. The payment of remuneration to a director, or the granting of a loan to a director or a member or the conferral of any other benefit on a director or member. F. The making of a contract between an interested director or a member and the company. G. The entry into a major transaction. Or H. The ratification after the event of any action which could have been authorized under this section. Section 302, Conversion of private company to public company. 1. A private company shall be converted into a public company. A. If the company alters its capacity to operate as a private company. And B. Where the company alters its registered constitution in a manner that is appropriate to a public company and not required in order to constitute a private company. 2. Within 28 days after the date of the special resolution to alter its capacity to operate as a private company or alter the registered constitution, the company shall deliver to the registrar for registration a copy of the resolution in accordance with Section 165. 3. The registrar shall publish notice of the conversion of the company in the company's bulletin. 4. Where there is a default in complying with subsection 1 or 2, the company and an officer of the company that is in default is liable to pay to the registrar an administrative penalty of 500 penalty units. Done.